Hello, welcome back to TELECOMRECORD Entertainment Immigration Updates. The K-Class visa is a non-immigrant visa category. It is widely used for a loved one of a U.S. citizen to join them in the United States. The K-1 class explicitly is for a fiancé to join his or her partner in the United States. Have you experienced a fiancé visa denial? If so, it could have been denied for many different reasons. It is important to know how to address issues specific to your K-1 fiancé visa denial case. The overall number of applicants to the K-class category has been relatively steady for the past decade, with some fluctuations due to changes in presidents. For example, under the Obama administration, Democrat, K visa class saw an increase in approvals, while under the Trump administration, Republican, K visa class saw a decrease in approvals. As with other U.S. visa types, the political party in power and their views on immigration policy can dramatically change the approval and rejection rates. Having your fiancé visa denied is common. More than 15% of all K-1 category visa applicants had their applications rejected in 2021. This amounts to over 4,000 rejected visas. However, this K-1 visa denial rate is not surprising. This is because it is a visa category that is at high risk of fraud. Some experts cite a wide range of reasons for rejections. Furthermore, it is important to note that, on appeal, most denials are reversed, with only 45% of appeals being unsuccessful. Rejection versus denial. While these two terms may seem synonymous, they actually have very different meanings in immigration law. Your fiancé visa is processed in two main stages. During the first stage, your petition will be looked over to ensure that all of your information is there and that the necessary documents filed and the fees are correct. If your petition fails this stage, it will probably be rejected. If it passes, it will move on to the second stage. Here, the evaluating officer will determine if you are eligible for a fiancé visa through information gathered by your petition and through your interview. If your petition fails this stage, it will likely be denied. If you are interested in any of these topics, please stick around till the end of this video for your immigration updates. If you like this video, please hit the subscribe button, like this video, and click the bell icon, so that you can instantly receive any new updates right on YouTube homepage of your smartphone or smart devices. Now, let's get into the video. So, here are the top 10 reasons for having a fiancé visa denied. There are many reasons why visas are denied, some more common than others. This is because there are diverse rules and unique circumstances for individual cases. However, based on our experience, common K-1 visa denial reasons are as follows. Number 1, insufficient evidence of a genuine relationship. The K-1 visa is one of the most heavily scrutinized U.S. visas. Immigration officers will look at every available avenue to determine whether your relationship is bona fide or not. Any red flag in this regard may lead to denial. Some of the reasons include a significant age difference between you, practicing different religions, having distantly different cultures, no common language, getting engaged shortly after meeting for the first time. Note: the above conditions are not necessarily an automatic prerequisite for K-1 denial. However, they are some issues that will require more diligence and details to prove. This is because it generally raises suspicions when two people in a relationship do not have much in common. Number 2, insufficient evidence that you have met in person. Not meeting basic requirements, such as meeting your fiancé in person at least once in the preceding 2 years, is a red flag that may lead to denial. This is one of the criteria to judge the authenticity of your relationship. You must provide adequate proof of these meetings, which may include photographs, hotel reservations, flight tickets, etc. This proof must be in accordance with K-1 visa application guidelines. The meeting must be in person, as phone conversations, Skype calls, social media messages, and other meetings via electronic means of communication will not count for this requirement. However, in case it is extremely difficult or impossible for the two of you to meet in person, you may request a waiver for this requirement. The USCIS may grant a waiver on two conditions. 1. If your meeting in person will violate the strict customs of your fiancé's culture. 2. if meeting in person will put the U.S. citizen sponsor in extreme hardship. Number 3. Failure to meet income requirements for K-1 visa sponsor. There is a stipulated income level required for K-1 visa sponsors. The U.S. citizen sponsoring the K-1 visa must sign an affidavit of support to demonstrate his or her financial ability to provide the financial needs of the foreign fiancé. The affidavit form must reflect that you are capable of meeting your personal needs, those of your fiancé, and of every dependent member of your household. At the very least, you must show the minimum requirement, which is 100% of the HHS poverty guidelines. The amount will be dependent on the number of people in your household and your state of residence. This is because the higher the cost of living is in a state, the higher the income requirement, according to the HHS guideline. Here is the full detail of income requirements for K-1 visa sponsors. Number 4. Failure to demonstrate readiness to marry in 90 days. One of the crucial requirements of the K-1 visa is that the couple must be ready to get married within 90 days after the foreign fiancé's arrival in the United States. This must be proven with a signed statement, indicating your intention to get married within that period. Having supporting evidence for this will be a great boost for your petition. For instance, if you've already fixed a date for the wedding, printed the invitation, and paid for some elements of the ceremony, you can submit the receipts of the items bought, your wedding invitation card, and other relevant items to reinforce your signed statement. While this is a very important requirement, you may also get a waiver for it if there is a genuine reason that can cause you not to get married within the stipulated 90 days. For example, if there is a delay with a prenuptial agreement, a medical issue, or any other verifiable, legitimate reason that justifies the delay of your wedding. Number 5. Not legally eligible to marry each other. Your K-1 visa petition may be denied if one or both of you do not meet the legal requirements to get married in the U.S. The most common scenario is when either or both of you haven't terminated your previous marriages. If any of you has been married before, the marriage must have legally ended before you can be eligible for a fiancé visa, either as a beneficiary or petitioner. Legal termination must be proven with documents showing divorce, annulment, or death of the previous spouses. Number 6. Filing K-1 visa after recently divorced. Keep in mind also that filing a K-1 visa after recently divorcing may raise suspicions. The officers adjudicating your case may become suspicious as to whether your new relationship overlapped while you were still married to your former spouse. If you find yourself in such a scenario, you will need strong evidence to prove the genuineness of your relationship. Number 7. Secretive relationship. If no friends or relatives are aware of or involved in your relationship, this may also arouse suspicion from the immigration officers. Most bona fide relationships that lead to marriage usually include their family, friends, and/or colleagues at work. If there is no evidence that other people were a part of your relationship, you may run into issues. You can avoid raising suspicion on this ground by presenting some group pictures of the two of you that also include your family and friends. If there are no pictures for this, other documents that can help prove this can be provided. Number 8. Contradictions. Making contradictory statements during your K-1 visa interview or in the documents you submitted can lead to the denial of your K-1 visa petition. For instance, if your paperwork says one thing and you give a different answer during your interview, this could portray you as a dishonest applicant and may lead to a denial. Another thing to avoid is visible nervousness or incoherence during your visa interview, so always be sure to speak confidently and clearly. Number 9. Failure to comply with the International Marriage Broker Regulation Act, IMBRA. The IMBRA was enacted in 2005 to check the abuse of marriage-based visas. The act compels a petitioner of a K-1 visa to provide information regarding certain past criminal convictions. This can include cases of sexual abuse, crimes, slavery, domestic abuse, violence, substance abuse. If you are found to have been involved in any of these crimes, this could lead to the denial of your K-1 petition. Also, the immigration officers may decide to release the information to your fiancé. This is to enable him or her to know the truth about the one he or she intends to marry and make an informed decision with that knowledge. The act also covers online dating platforms. If the two of you met online, your petition must include the details of the website and how and when you met there. The details must also show that the foreign fiancé authorized the dating platform to release his or her contact information to you. Number 10. Overly zealous verification. It is common for officers to require additional verifications for K-1 visa applications. This can be particularly burdensome when the fiancé had previously received a U.S. visa to visit their U.S. partner and shortly after getting proposed to. On many occasions, couples would apply for a B visa because it could be relatively easier to get compared to a K visa and don't have the psychological weight of marrying once the fiancé arrives. However, right after the fiancé returns back to their home country, their U.S. citizen would propose. Later they would apply for a K-1 visa. On the facts, this kind of situation can fall under Section 212A, 6CI, misrepresentation decision. This would result in a ban to U.S. entry and would require a waiver. Depending on the office or consul who reviews your file, they may pursue the review of your K-1 application in various manners. Some may overlook your fiancé's previous B application or not make the connection with Section 212A, 6CI. Others would pursue a deep review of the travel history and immigration history, which may result in unwanted consequences. Other reasons for K-1 visa denial. Although the above 10 reasons are highly common to receive a denial for your fiancé visa application, there are many more reasons that you should be aware of, such as missing time restrictions and limits that apply to documents gathering, having a criminal record or certain medical conditions, misrepresenting facts, documents, or other application-related data. Also, not proving intent to marry can result in visa rejection. Your fiancé visa may be denied at the interview because of an unconvinced consular officer. Not convincing the consular officer of the legitimacy of your relationship is a major contributor to visa rejections. It may even be better to get married and then apply for a spouse visa. Officially published statistics only point towards an overall list of reasons given for the denial of non-immigrant visas. This list is very general in nature. However, it must be noted that documentation-related administrative mistakes or missed deadlines can easily result in denial. Always ensure that your documentation is in order. Also, consult an immigration advisor to look out for dependencies overall. We will release new video when more updates are available. I hope you found this video informative and helpful. Thanks for watching TELECOMRECORD Entertainment Immigration Updates. This channel is dedicated to provide every information, visa processes that are required for your U.S. immigration journey.